Good afternoon, everyone. Welcome on behalf of Trust Mediation. People are still joining the meeting, so I'm going to leave it for a minute or so, and we'll make a start. See, people are still joining, so I'll leave it just a little longer. Good, let's begin. Well, good afternoon, everyone. Welcome on behalf of Trust Mediation to this lunchtime webinar, the second in our 2026 series. My name's Tim Wallis, and I'm joined on screen, as you will see, by our guest, His Honour Judge Alex Relton, and my fellow mediators, Andrew Hannam and Lea Brocklebank. One or two housekeeping points to deal with. We're going to run for 1 hour today until 2 o'clock, and we will finish then. Questions, please put your questions or observations in the Q&A or in the chat as we go along. And we do welcome challenging questions. When you ask a question, feel free to state your name or remain anonymous. I'm going to mention also that we have another webinar planned for you, and that is on the 25th of March. We may be saying something about neutral evaluation, we may be saying something about new mediators, or we may be continuing some of the topics we're dealing with today, but that will be advertised in due course. Our session today comprises two parts. Firstly, a talk by Judge Relton with a Q&A session to follow, and then Lea and I will introduce the new and the originally advertised topic, making better ADR decisions in PI and clinical negligence cases. So let's get on with part one. And I should mention that the recording, I hope we will stop the recording when we get to the Q&A session. So this session will be recorded, but not the Q&As. Andrew, may I ask you to introduce our guest?
Yes, thank you, Tim. I'm absolutely delighted that Alex has kindly taken time out of his busy day to address us today. Alex and I have been discussing mediation. Probably, I was thinking about it, Alex, must be going back some 10 years. Alex has always been very interested in mediation. I think probably initially maybe a little apprehensive about how any court orders could fit into the mediation scheme, or perhaps turn it around the other way, how mediations could fit into the court system. But in due course, Alex did agree that it would be worth looking at it, and set up a small pilot looking at cases which were issued on the multi-track and which would be subject to a stay when they came up to cost and case management conferences. That all happened well before Churchill, and I think what has happened subsequently and is now being seen across the national court system can be said to really build on what has been happening in Bristol for much longer. And I certainly take my hat off to Alex for having the foresight to see the way that mediation and mediation orders would become part and parcel of everyday court life. So I'm delighted now in the post-Churchill era for Alex to come and speak to us, perhaps to give a little bit of history behind how the Bristol mediation scheme worked. And I'm particularly interested to hear how Alex sees the reaction of parties to orders that are now being consistently made for proceedings to be stayed to give mediation a chance to resolve matters. Alex, over to you.
Thank you, Andrew. Good afternoon, everyone. By coincidence, today happens to be my wedding anniversary, but the good news is that I remembered it this morning, so all being well, I won't have to partake in any ADR, at least today. In the meantime, where are we with ADR? as I'm sure you all know, the English legal system, by which I mean both law and process, has always been and remains heavily reliant on precedent. When we've always done something in a particular way, that's the way we are going to do it. And that is also a very human approach. It means that significant change, absent an act of Parliament, can be very difficult. And even if you achieve the change, changing culture and attitude can likewise be especially difficult. And that is what I have seen with ADR and mediation, albeit matters are vastly improving, because let us all remember that litigation for ordinary, regular individuals is an extraordinarily painful exercise, extraordinarily expensive, and often extraordinarily long-winded, looking at the date from when your legal rights were infringed to the date when you finally achieve, to use that dreadful word, closure in all respects. Inevitably, some forms of dispute are more amenable to ADR than others. Those disputes where there's a middle ground that can perhaps be identified, I think in particular of family cases involving children, divorce cases involving money on dissolution of marriage, boundary disputes, rights of way disputes, perhaps patents, trademarks and such like. Because there can be a middle ground, it is perhaps easier for the parties to find that with the assistance of ADR. Whereas money claims tend to be rather more difficult, especially when you have hotly contested liability, albeit the quantification side of things may be rather easier. From my experience of having dealt with ADR for some time now, and indeed prior to having the current day job, I was for a little while a mediator in my own right. The problem with monetary claims is the commercial overlay. There can be significant factors pulling a party away from properly contemplating ADR. There may be, and I have to say I'm not privy to the finer details, taxation considerations. When do you want the liability to crystallize? Does that mean that you avoid the liability for as long as possible? Are there third parties involved, typically underwriters? Is litigation funding involved? Are there others who have a direct interest now in the litigation? And then, of course, above all else, we have what I regard as the Trumpian issue. Now, the President of the United States of America is famed for many things, and I hope he will understand that I choose not to comment on most of those things. However, he is well known as being the author, I think possibly to some extent co-author, of a book known as The Art of the Deal. And that perhaps is what is causing the handbrake still to be applied, in my view, to resolution of some civil cases, that the party, potentially nearly always the one who may be liable, is trying to carve a deal, achieve the lowest possible price. Incidentally, in the current legal dispute over the pond between Mr. Trump and a little organisation you may have heard of called the BBC, I gather that has had mediation imposed on it before any further steps are taken. So where are we in England and Wales? We saw a sea change, I think, with the introduction of the civil procedure rules and the pre-action protocols, the cards on the table approach from the set-off. I took the opportunity to have another look in readiness for this talk at the infamous cases of Howson and Milton Keynes General NHS Trust, and also the more recent Churchill case. Now, Howsey, we may remember, was a dispute about cost sanctions being imposed against an unwilling, against a party who was unwilling to mediate. And in the lead judgment given by Lord Justice Dyson, at paragraph 9, he said, "We heard argument on the question whether the court has power to order parties to submit their disputes to mediation against their will. It is one thing to encourage the parties to agree to mediation, even to encourage them in the strongest terms. It is another to order them to do so. It seems to us that to oblige truly unwilling parties to refer their disputes to mediation would be to impose an unacceptable obstruction on their right of access to the court." And of course, the right of access that the learned Lord Justice had in mind is Article 6, the right to a fair trial. However, that sort of attitude, of course, neglects consideration of the fact that mediation is a process. It does not result in the imposition of any sort of final order on a party. They must be willing to sign up to the terms of settlement. Furthermore, no one is suggesting that in any sense a party should be deprived of access to the court. All that is simply being suggested is that parties should try to resolve their disputes before they go all the way to a trial. Preferably, in my view, before they go all the way to issuing a claim. But of course, particularly in personal injury world, there may be all manner of legal reasons why a claim has to be launched. That, of course, took us to the case of Churchill, where the Court of Appeal, I am sure, will be very insistent that they most certainly, through the words of Sir Geoffrey Voss, Master of the Rolls, did not perform a U-turn. Albeit, at paragraph 19, Sir Geoffrey Voss said, "In my view, in considering Dyson's full reasoning, it is even clearer that his ruling on whether the court had power to order the parties to mediate was not expressly or impliedly a necessary step in reaching the conclusions on the cost questions decided in the two cases." And then at paragraph 20, "Accordingly, I've reached the clear conclusion that paragraphs 9 to 10 of the judgment in Halsey was not a necessary part of the reasoning that led to the decision in that case." And then, of course, the decision that was reached in Churchill, which was certainly not a U-turn, we mustn't use those words, was that a court very much could impose mediation on parties. The rest, they may say, is a matter of history. I'm sure everyone present is familiar with the changes to the civil procedure rules to make it abundantly clear that the court can impose a mediation. Other forms of ADR, of course, are available. But what we are not really talking about here is arbitration, which is normally a form of dispute resolution agreed in advance of a legal dispute as a matter of contract. Now, where does that take us? When I first started discussing the matter of ADR with Andrew and others, there were two very real questions. Firstly, and these were in the pre-Churchill days, can the court impose a mediation on the parties? And secondly, when should the mediation be imposed? At what stage in the process? So far as the question, Can a court impose a stay on the parties to facilitate mediation? We all know, of course, yes, it can. It's quite right that I was nervous, extraordinarily nervous at first, before the courts were rearmed with the powers from Churchill and the changes to the CPR. But perhaps the more interesting question is the timing. When do you mediate? Now, here's the thing. In the personal injury world, with which I suppose I am most familiar as a judge, because it is the largest part of the loaf and the butter in the county court, there has long been a culture, it seems, of every last piece of lay evidence and expert evidence being obtained before the parties are prepared to try to resolve their differences, both with respect to liability and with respect to quantum. And therefore, we have had a culture in the county court, which exists to this day, of cases settling at the 11th hour, frequently in the 59th minute of the 11th hour. I still have cases where I have pre-read the trial bundle, got robed up, been informed by my clerk that counsel are talking, they ask for time, and then with expressions of absolute pleasure on their faces, because they know that the trial judge will be happy, they say that they have settled. The trial judge isn't especially happy because he just spent last Friday reading a trial bundle and absorbing and analysing information and evidence in advance when there was absolutely no need to, and he could have been doing other work, with a brain that doesn't have a simple delete button like a computer, and now faces a prospect of the next 3, 4, 5 days of trying to find other work. So last-minute settlements are not especially good for the court system. So this got me thinking, in consultation, as I say, with Andrew and others, when should we impose mediation? And the answer, surely, given the pre-action protocols, is as soon as possible. So judges do not tend to see a case, and I'm talking about multi-track cases, until, to use the old words, the pleadings are closed, the directions questionnaires are completed, and the papers are then sent out, still largely in paper form, but soon to be in PDFs, to the receiving court, where either the claimant or the defendant is based, etc., for consideration by a judge for the very first time for the purposes of listing a cost and case management conference. And then we know that it's from that point forward that the costs really, really soar. What is it that's going to happen from that point forward that is realistically going to better inform the parties what the liability issues are and what the general shape is of the available evidence about liability? There shouldn't be any surprises on disclosure. It's a formal process, but the disclosure of important material should already have taken place. Surely everyone knows what every witness of fact is likely to say. It's unlikely expert evidence is now going to be required on any liability issues. In a serious road traffic case, for example, you will probably have the police accident reconstruction report. So what is the problem? That's liability. And then so far as quantum is concerned, nearly always the claimant will be largely tooled up with whatever evidence they need in non-injury cases. The amount of losses they say they incurred by reason of breach of contract or by reason of a tort. In personal injury cases, of course, the claimant should have the general shape of their medical evidence. And in many cases, medical evidence is fairly straightforward. The fracture is there to be seen. The scars are there to be seen. Is it really worth, at this point, both sides spending nigh on an additional £100,000 and, of course, sums north of that for the more serious cases, when nearly all of the information is there in place? Why can't they mediate? And indeed, why can't they at least try to mediate liability, mediate quantum? And let us not forget, I regard certainly successful mediation as resolving any issues. So you may transform a case with many, many issues into at least a case of a few discrete issues. This would be exceedingly helpful. And thus in Bristol, with help, I crafted a state mediate order. So from some years ago now, each and every multi-track that came to Bristol came to me via court staff, so far as court staff remembered to do that. The problems being that whenever you have a change in court staff, you then have to teach the rules all over again. But it's been fairly successful. And I explore the file, which should at this point in time, of course, have the pleadings, have directors' questionnaires, have quite a lot of information on it. I do check to see whether there are any discrete issues that might worry me. Is it a case where domestic abuse may feature? Is it a case where coercion control may be exerted through the very litigation itself? Is it a case where one party in particular is in person? Has it got anything to do with credit hire, in which case I'll try and transfer it to the north of England? Of course, I didn't say that, but there are some cases which are so incredibly hostile to mediation that you don't even try, and credit hire is certainly one of them. But otherwise, if it looks to me like the case is reasonably up together, and for example, it's not a desperately complicated case where the claimant has had to issue, but the medical evidence is far from complete, then I will consider staying to mediate. And of course, with the last example I just gave, incomplete medical evidence, the liability question could still be mediated. And so that is what I've been doing for some time now, with respect to all of the heavier duty multi-tracks. Since the introduction of the intermediate track, which, as you will all know, takes you from 25,000 to 100,000, I have steered clear of imposing mediations in intermediate track, not least because the fixed cost rules do not make provision for ADR or mediation within the intermediate track. And also, if it's a multi-track, simply because it's an older case and it's only just into multi-track, in other words, a slightly bigger fast track, then I won't impose stay to mediate. When I first started doing this, there were a number of cases where there was real willingness to mediate. And that was a pleasure. And I imposed the initial stay to mediate period was always 3 months. It struck me that any less than that simply disallowed sufficient time for the parties to have a chin wag and at least agree on a mediator and then arrange the mediation. So I thought it had to be at least 3 months. And we have had and still have a number of cases in Bristol where the parties have come back asking for an extension to the stay. Sometimes because they have had a mediation which has nearly got them there, but not quite, and they want longer. Sometimes they have agreed that there's something else that needs to be done before the mediation, but they still want a mediation. The earlier pushback came from the employment liability cases and the road trafficking cases, especially from the defendants' insurers. I can give you a summary of all the manner of reasons. Quite often you see the reasons why in the directions questionnaire. Is the case suitable for mediation? No, liability is in dispute. Is the case suitable for mediation? No, causation and injury and damages is in dispute. Well, that presumably means that no case is ever worthy of mediation. And there were all of these pushbacks, which I generally refused. I said, no, you will mediate. Without doubt, there have been a number of cases where they have sat it out. They have simply waited for the time to pass. Well, so be it. In those earlier cases, before Churchill in particular, given Halsey, it was difficult to think of any sanction that could really be imposed. As a judge, I occasionally had argument of, we offered mediation, they refused. I would make an adjustment in costs, but it tended to be really quite modest. Dare I say it, probably not painful enough to make the resistant party, open brackets, insurer, question mark, close brackets, think again about being resistant to mediation. Now, of course, we are rearmed, that is the courts, and proper cost sanctions can be imposed against someone who unreasonably resists mediation. But as I say, we still have a number of these cases that I think the parties are still sitting it out, waiting for the time to pass. The party who is willing to mediate, of course, has at least got wise and sensible to the fact of ensuring that it's there in the correspondence saying, come on, let's mediate, come on, let's mediate. If you don't mediate, then we'll make the point when cost is useful to be considered. And that, without doubt, is a useful step. A little while ago, I was asked by Lady Justice Sarah Asplin, who I'm sure you know is very interested in ADR. She asked me how the Bristol scheme was looking. And because there is no HMCTS system as such, which helps gather evidence about how the Bristol system is going, I've been doing the task myself on my little laptop computer with a table, trying to assemble some degree of evidence about the success or failure of STM. What I'm pleased to say is that there has been a percentage increase in settlement. Now, of course, I am not privy to the mediation itself. The Tomlin order, almost inevitably, the consent order is in the form of a Tomlin order, doesn't really tell me anything, except in the more complicated property disputes, perhaps, what they sorted out between themselves. But I am pleased to say that it is working. I believe the message is getting there now, generally, to the judiciary as a whole, including the case managing judiciary, to think about mediation. And I think we are now seeing culture change. I would like to see more culture change in the traditional employer's liability, road traffic insurance type cases. But it's getting better. The last insurance case, if memory serves, that resolved following a mediation was, of all things, nothing to do with employer's liability, nothing to do with personal injury or road traffic, and it was all about knotweed of the Japanese sort. So there would be a case which you would have thought might have fought tooth and nail all the way to the end, but no. And I recall that insurers were involved in that. So that is an overview of where we have got to with respect to ADR. You will remember that in Churchill, the Court of Appeal declined to assemble any sort of checklist with respect to cost sanctions or with respect to when a case should be forcibly mediated. But I think we can see that mediation is the way forward. Now, I asked myself the rhetorical question, what would I want to do if I were the victim of something? What if I were the victim of, say, a clinical negligence? Would I really want to take the allegedly negligent surgeon to the cleaners? Do I really want my day in court? No, I don't. I want my dispute resolved swiftly and civilly. And what better way to do that than with ADR? There we have it. A judicial perspective, which I wish to emphasise is my perspective. I'm not speaking on the part of the judiciary as a whole, on ADR. And I'll now do my best to answer any questions if anyone has any questions.
Alex, thank you very much. I invite our audience to put questions in the Q&A or in the chat. Meanwhile, I will ask Andrew and Leah if they have any questions. I certainly have a couple I would like to put. Andrew, can I turn to you first?
Yes, one of the questions that was bumbling around in my mind, as I'm no longer in active litigation practice, I'm mediating full time. One of the questions that I had in my mind was this. You're imposing stays to mediate pre-CCMC. If the case does not mediate and comes to you for a full-blown CCMC, do you at that stage explore why mediation hasn't happened? And do you consider at that stage making any orders to encourage the parties to reconsider?
Hopefully that is something that the case managing judge is asking. And it's going to be one of those judgecraft exercises in probing without probing too far. But certainly, if there hasn't been mediation, I see no reason why the judge cannot probe. And certainly, in the few cases that I deal with at CCMC, because the vast majority are dealt with by district judges, I will certainly explore timetabling in a mediation. If, for example, the parties are ad idem that a certain step must be taken, and then they can start talking Turkey, I'll say, right, well, let's timetable that in.
That sounds very sensible. Thank you, Alex.
Leah, anything from you? I have a question from the audience, but I'll give you an opportunity first of all.
I can ask a quick one, really. Good morning. I just wondered why you were thinking to exclude litigants in person, and why you didn't feel they would be suitable. Thank you.
The real dispute, the real issue there, well, a number of issues. Firstly, cost, because a mediator has to be paid for, and there tend to be ancillary costs. Secondly, if you have a represented party on one side and the litigant person on the other side, then for many LIPs, they are not going to perceive there being any sort of level playing field. They're going to see it as lawyer plus lawyer plus lawyer versus individual. Also bearing in mind that whilst there are some very intelligent, articulate LIPs out there, there are also those who are of less capability. And one cannot avoid the fact that there may be an element of unintentional coercion. So for the time being, I feel that it would be inappropriate to impose a mediation on a litigant in person as a paper exercise without there being a hearing. It would be different at a CCMC because, again, it would be something I would explore.